the way in which we have this seminar, due to actually few today's seminar. And I'm really grateful to our today's speaker for having accepted our invitation to participate to this seminar series organized by the Galileiana School of Higher Education, University of Padova. And Valentine Lomellini will introduce today's speaker, and thank you to every participant for being with us today.
Thank you. Thank you to Antonio Nicolò, also for providing some useful information for participating in this meeting. So first of all, I'm very glad to welcome Prof.ssa Sara Pennicino, who is a colleague of mine. She is Associate Professor of Comparative Public Law at the University of Padova, where she teaches in constitutional development and democratization. And she's also adjunct professor of international law at the Johns Hopkins School of Advanced International Studies, Europe. She worked on several subjects, and her main research area of interest include electoral management in transitional post-conflict countries, systems and electoral justice, constitutional ban on political parties, and constitutional eternity clauses. Sara also works with the Center of Excellence for Stability Policy Units, training Italian inter-country members of security forces with specific regard to human rights and policy and security and humanitarian law. So I'm very glad to have you here, that you decided to join us. She worked on this subject also. She's going to present a paper today dealing with human rights protection in the EU vis-à-vis populism and democratic degradation in member states. So a very current day affairs, I would say. Sara, are you able to share your PowerPoint presentation? Because I have here, but maybe do you prefer to do on your own? We don't hear you.
Are you able to see it?
Yeah, it's okay. Fine. Thank you very much.
Working. Perfect.
So we will try to, we ask you to maintain your presentation in 45 minutes, and then we will leave some floor for, some ground for questions. So I leave you the floor, and welcome again. Thank you for joining us.
Thank you very much. Thank you, Valentine, and thank you, Antonio, whom I don't know, but it's great to meet you, despite virtually, and I am very honored for the invitation. Before I move forward, I just want to clarify, I don't know what the policy of the Scuola Galileiana is with the language. I apologize for pushing the use of the English language. It's just that this is the language that I normally use for my lessons and my presentations, so it was just easier for me. I also understand that there are international students, students from different fields with different backgrounds. So I thought that, well, in the context of the topic that was identified by Valentine and the topic of the seminar series that you're both hosting, I thought that the topic of democratic decay and putting democratic decay in Central and Eastern Europe particularly, but not only, in relation with human rights protection and what the European Union could do and is trying to do to halt such process. I deem this particularly important because from a strictly legal standpoint, there are a lot of strategies and there are a number of options that can be followed. My presentation will be mainly focused on legal issues because that is my field of expertise, but I thought that the topic opens to a certain type of discussion from multiple fields. So I think this is going to be, hopefully, this is going to trigger an interesting debate. I understand that I'm going to speak first and then you're going to ask questions. Okay, so I hope that you're going to find these sufficiently interesting and to have questions to note down and then share at the end. So, as you probably are all aware, some authors, maybe not in the technical debate, not in the legal one for sure, but maybe on newspapers, on the more general debate, some people have been talking about a possible European Union civil war. Like if in the latest time, the European Union was split in between two different components, or at least was dragged in two different directions by forces that are aimed towards contrasting political aims, or at least political developments. One is that represented in this picture by the guy that I think everybody at this point, everybody knows this person, because it has become one of the most famous, not popular, but famous prime minister in Europe, which is Viktor Orban, who is the prime minister of Hungary. And of course, for the European Union, here in the picture, we have the president of the Commission that, again, if you did not know exactly her name before, by today, you probably do know her very well, because you've seen her on all the newspapers and all the media titles due to the unfortunate event that occurred in Ankara. These pictures represents very well the tension that apparently has developed between Brussels and the European Union institutional directorate and a number of member states that have been developing different ideas about what should constitute the very nature of a liberal democratic system, or better. They have elaborated the idea that the concept of liberal can be taken away from the definition of what a constitutional system is in the context of the European tradition. And this I am not saying, let's say, indirectly, as I'm desuming it from multiple factors. This has been clearly declared by Orban itself, which once openly and explicitly admitted that his political project was and is to build an illiberal democracy in Hungary. Now, from a constitutional standpoint, the idea of an illiberal democracy is interesting, again, air quote, is interesting for multiple reasons. First, because after the Second War, at the end of the Second World War, constitutional lawyers have approached the idea of a constitutional state and liberal democracies from a very specific standpoint. There is no alternative to the model that we have known and that we have studied and that we have consolidated through constitutional interpretation up to this point. It is overwhelmingly worrying us, the idea of being able to keep the tag of democracy but keeping away the liberal part of it. Of course, this also resonates at a larger level, which is the international one, and the old decay and the old demise of the idea of liberal peace. But we're not going to tackle that today, which is definitely a completely different kettle of fish that would be opening a Pandora box. So in this civil war, not only this is a war of idea, but this is also a legal war. In an attempt to stop or try to minimize this decay of the quality of democracy, explicitly sought by the political elites of a number of member states of the European Union, the Union itself has tried to put in place and to use all the legal instruments that the Union has to counterattack. The most well-known instrument is, of course, Article 7 of the Treaty on the European Union, and we will talk about that in a second. But before we go on and analyze the legal aspects, just to give you an idea of how topical this issue is, this conflict is, think about the fact that not later than 20 days ago, Poland and Hungary moved for a legal action against the Union because they think that it is out of the competence of the European Union to condition the access of member states to the so-called recovery funds to the democratic performance, and more specifically, the performance of member states with regard to the rule of law. Now, bear in mind that we're talking about an historic 1.8 trillion budget investment by the Union being moved to member states, and trying to condition that type of financial support to the respect of the rule of law and the respect of a very specific idea of what a democratic state is, it's a very complex attempt. And this attempt is justified, or at least is connected in Europe to the German tradition of the idea of a democracy attempting to protect oneself, right? So without, again, getting too much into the details of this constitutional doctrine, according to German constitutional law and according to the German constitution, when a constitutional rule is abused by any political majority in order to undermine the very basic democratic features of the constitutional system of Germany, that at that point, there might be some reaction from the system, and certain fundamental rights that are protected themselves by the constitution can be curtailed. Long story short, the best example is there are certain political parties that are banished from the political competition in Germany. There are certain political parties that cannot be created and cannot run for elections in Germany. Who decides who these political parties are? The Constitutional Court. So again, this is not the result of a political process. This is not the result of a political debate. This is a constitutional legal rule. There's case law on the topic. There are precedents. Any further attempt, any more recent attempt, for example, to ban a political party in Germany has failed. Most particularly recently, an attempt has been made with respect to the ADF, to the right-wing party that has been performing quite reasonably well at the both regional and national level. But when the case was brought in front of the Constitutional Court said that the conditions to ban this political party from the competition were not there, or at least not the same situation as in the case of the parties that were banned in the 50s and the 60s. All of this said, this is the type of heritage that measures like that of conditioning investments to the respect of rule of law and of certain specific characteristics of what a democratic state is, links back to. Now, the idea that the money is linked to the democratic performance is actually part of the agreement, but up until very recently, it had been framed as wishful thinking, saying, oh, it's in the agreement, but we're not going to trigger it. We're not going to process for real. We're not going to test you. We're not going to process a test on the quality of the democratic system in individual member states. Plus, we are most likely not going to assess the quality of the rule of law in individual member states. But with the recent developments in both Hungary and Poland, actually, this became more real than anyone had expected. For this reason, the civil war in the European Union is now between Brussels, who is willing to trigger for real the assessment on the rule of law in member states as a condition to access the new fundings, the post-pandemic fundings. And on the other side of the conflict, you have mostly those that we tend to call the countries of Visegrad Pact, but it's mainly Hungary and Poland. On the other side, you will have Hungary and Poland that have sued the European Union, saying, you don't have the right to do this. No one ever gave you, from a constitutional standpoint or an international law standpoint, the right to act as the guardian of a specific idea of rule of law and of democracy. Nobody ever gave you that competence, that task. So you're acting outside of the delegated competence that we signed up to when we signed and we adopted the Treaty on the European Union. Again, as I anticipated, the main instrument, the main tool that the European Union has in order to legitimize any intervention, any assessment on the rule of law performance at a level of member states is Article 7. At this point, you're probably very much familiar with the Article 7 procedure, because it's the one that not a long time ago ended up in a debate in the European Union Parliament, where a report on specifically Hungary was presented by a European Parliament representative, arguing that the level of the means of the rule of law in Hungary was such that the European Union Parliament was willing to trigger the so-called procedure of Article 7, which may lead eventually, and after a lot of different phases. So, sit tight, don't worry, nothing is going to happen tomorrow, but may eventually lead to the exit of that member state from the European Union itself. There's, though, another recent innovation with regard to the toolkit of the European Union as the guardian of the rule of law in member states. And that new tool is the rule of law report. The rule of law report, and again, I'm only talking about legal tools, okay? Of course, there can be diplomatic talks and there can be other instruments that are outside of the scope of my expertise. But in legal terms, the second new instrument is the rule of law report that was very recently presented by the president of the Commission. And this rule of law report basically assesses the performance of every member state with regard to the rule of law. It does not focus on bad performances only. It does not point the finger towards those that are very badly performing. It is an overall assessment of all the member states, and it's actually structured by themes. That, on the one hand, was supposed to help making the rule of law more, let's say, agreeable to the member states themselves. On the other hand, this strategy raised a whole series of criticism by older member states, by member states that are normally considered to perform very well with regard to the rule of law, because they said that this approach was not clear enough in pointing the finger towards where the real problems were. Now, this introduction is dramatic by definition. I've talked about civil war, I've talked about rule of law demise in member states, I've been talking about expulsion from the European Union. I understand and I admit it is a little dramatic. If I did not know already what is coming afterwards, I would imagine that such reactions, such dramatic reactions, had to be triggered by very flamboyant action taken by member states, right? That Viktor Orban that we saw before, I would imagine this guy must have done something explicitly evil. He must have done something like declaring a whole chunk of the population ineligible for election, or he must have kicked out a minority from the country. I mean, it's got to be something substantively non-democratic and substantively not liberal. Now, here I'm not arguing that both in Poland and in Hungary, substantively illiberal and undemocratic legal decisions have not been taken. However, my argument is that most of the attacks on the rule of law in these member states are actually carried out through procedural amendment to the law. Let me explain better. Often, especially if not analyzed from a strictly legal perspective, it is difficult to see how the first step and the greatest majority of the attack on liberal democracy is carried out through the adoption of new procedures, of new procedural rules that indirectly will violate human rights and will undermine, in the end, the rule of law and the quality of democracy in a given member state, in a specific member state. So when a political majority that has this specific agenda, when they win the election, they get a lot of electoral support, what they will do normally, it's not to adopt immediately, evidently and substantively undemocratic laws, but it's actually going to tackle small procedural issues that all pieced together will actually have the same effect in the end. So the story I'm going to tell you today is exactly an example of this type of activity, and or better, of political action. And in the end, I will show you what the role of the European Union has been and can be in countering these attempts of attacking the rule of law through new procedural rules. Now, who's this guy? This guy is Mr. Alexei Turubarov. I am not 100% sure that the accent is being identified correctly. So if anyone in the audience wants to jump in and correct my accent, this man is a Russian citizen. He was a businessman, and then he became, he made some fortune during the transition, right under right after the fall of the Soviet Union, and during the Yeltsin time, he made some good money and some fortune in the restaurant business. He was a teacher. He was a school teacher, but then he undertook a business enterprise and he was successful. He got involved somehow with the authorities, and he ended up being identified as a political activist and as a political opponent, which after the end of the Yeltsin time was not, let's say, seen with favor by the new ruling class in Russia. For this reason, Alexei Turubarov was threatened. His property was seized, his family was threatened, and he deemed necessary to flee Russia and to seek for refuge in the European Union. So the first time Turubarov escapes and flies, and at least he arrives in the European Union with the intention to seek for international protection, is when he travels to Austria. So he travels to Austria, and there he files his first asylum request. I'm just going to give you some facts so that then we can go back and look at the technical details. At that point, he claims, well, at least he applies for international protections in Austria, and Austrian authorities say, well, we would give it to you because evidently you are in danger. If you were to be sent back to Russia, you would be in danger for your life and for the life of your family. And this is against international law on the basis of the rule called non-refoulement. It is illegal to send anyone who is seeking for protection back to a country where he or she will be facing inhumane treatment or torture. However, Austria says, it is not my competence because you didn't land directly in Austria, but the first time you set foot in Europe was actually in the Czech Republic. So the guy is sent, to Slovakia. So the guy is sent to Slovakia saying that was your entrance, right? And this is also the Dublin Treaty that you all hear about. This is the rule in the European Union. You have to go back where you first set foot into the Union. So the guy sent back to Slovakia. Slovakia has a lot of interest at that point with Russia and is not in the position to protect Turubarov. So it said, sorry, you have to go back home. You have to go back to Russia. In Russia, Turubarov, of course, faces again, and he's jailed again, and he is suffering the same type of threats and dangers that he had suffered before. So he decides to flee again, and this time he arrives in Hungary. And here starts our story. Mr. Turubarov is now in Hungary, and he applies for international protection. He wants Hungary to recognize his status as a refugee. He's an asylum seeker, and he wants to be recognized as a refugee. So what does he do? He files his application in front of the immigration office. Now, the immigration office in Hungary is an administrative office, okay? It's like going to any executive agency. It's not a judge. It's just an administrative post. He files his application, and the administrative immigration office replies that there is no serious danger of harm, so you gotta go back to Russia. We're not going to recognize protection to you on the basis of the facts that you submitted. At that point, Turubarov files an appeal in front of a judge, right? Because this is not a judge. This is just an administrative office. So he has the right to file an appeal against this decision in front of a judge. The judge, specifically the Administrative and Labor Court in Pech, says that actually there was no bias assessment. There was a bias assessment by the administrative office, and that actually this whole application should be reconsidered because, and they offer guidance to the administrative office for them to reconsider Turubarov's case. Now, what happens now is that a ping pong match starts, right? So you can see here, I'm not going to go through all the steps because it's boring, but he basically has a first rejection, then he files for an appeal, and the judge says, you're right, you should be protected. I'm going to send back this case to the immigration office, and I'm going to suggest them how to actually assess your case. The administrative immigration office doesn't want to hear about that. And they say that absolutely they're not going to change their decision. So Turubarov appeals again, and then the decision is sent back to the administrative office, and the administrative office keeps refusing to reconsider its decision. Now, if you were ever dealing with any bureaucratic procedure in your member state or in your domestic legal system, in your jurisdiction, you will know that there is nothing more frustrating and stranger than having a judge telling an office of the administration that a decision is wrong, and having this administrative office brushing off these appeals, saying, I don't care, I'm still going to do what I think is right, I'm not going to listen to the judge. In every liberal democratic system that you might be familiar with, a court is the place where a citizen can go to be protected from an illegal action from a political majority, right? So this situation is very strange. This ping pong match is very, very unusual. Usually when a judge says, do something, the administrative office will follow. Because this was the situation, the judge in Hungary got so frustrated that they decided to stop the ordeal and to send a question to the Court of Justice of the European Union. They decided to ask to the Court of Justice of the European Union, through a procedure that is called the preliminary ruling, whether it is acceptable for, in the light of what the European Union Charter of Fundamental Rights and in the light of the European Union laws on asylum seekers, on the directive regarding the application for international protection. So the court is simply saying, considering European Union law, dear Court of Justice, do you think that this ping pong between myself and this administrative office is acceptable? And do you think that this ping pong amounts to a fair trial? Do you think this is acceptable? That in a liberal democratic system inside the European Union, do you think that this is compatible with all the rules about human rights, rule of law, fair trial, international protection, and so on and so forth? Now, what is interesting here is that the Hungarian system has not been like this forever. It was very much different. But this amendment to the law that allows an administrative immigration office to brush off a decision by a judge, to ignore it and move forward with their own decision, was the result of very recent amendments. One, in 2015, on the law on the management of mass immigration, which, by the way, is by itself a very interesting title for a law, and as a consequence also of the 2018 Administrative Procedure Amendment. Now, this one, because of his title, may give away a little bit the agenda, the populist agenda, if you allow me to use this definition, the populist agenda of the Orban executive. But this one is very much less clear, right? It's not as evident that an attack on liberal democracy and the rule of law may occur through the amendment of the administrative procedural code. But this is exactly what happened. By saying that an administrative office could simply ignore what a judge is saying when it comes to international protection and immigration, they basically put forward their populist agenda, which was, we're going to take decisions on international protection on the basis of an executive interest, not on the basis of the law, not on the basis of a fair trial. We're simply going to take a decision, which is an assessment from the administration. Now, how is it possible that a Russian citizen who is not content with a decision of an administrative office in Hungary is managing to trigger a procedure in front of the Court of Justice of the European Union through a judge in Hungary? This is a very complicated path, right? You guys are right. Now, the reason why this is legitimate and this was possible, it's because the European Union has adopted over time a consistent body of rules on asylum seekers, on the rules on when and how to grant international protection. And of course, there's also a body of laws that is called the qualification directives. So when can you apply? When can you be recognized as an asylum, as a refugee? There is a procedure directive which deals with whether and how you should have the right to file a claim before a judge. Anyhow, it's a body of law, rules established by the European Union that member states have to abide by. They don't have to directly apply them, but they have to implement it through their own laws. Long story short, the point is that there was ground to challenge the very political and legislative strategy of the Orban majority, trying to curtail the possibility and the protection of asylum seekers from a procedural standpoint, basically undermining their human right to a fair trial, and to bring all of this again in front of the Court of Justice. And this is why they were able to do this. So there's a twofold problem here. One deals with the compatibility between Hungarian law and the directives, and the other one is between Hungarian law and the Charter of Fundamental Rights itself. Why is it also about the Charter of Fundamental Rights? Because this is basically all about how do we define a fair trial? And the way in which we define a fair trial is very much the core of the way we define the rule of law. So having an administrative judge being able to just brush off any decision by a court of appeal, does it integrate the very basic definition of a fair trial or not? And is the Hungarian law fulfilling the mandate of the European Union in implementing such rule of law and more specifically guaranteeing a fair trial to asylum seekers? By analyzing the directives, the Court of Justice of the European Union points to the fact that Article 46 of the directive speaks about a full and ex nunc examination. Ex nunc means from the beginning, not from the moment the court is examining the case, but considering all the relevant facts from the past, from the very beginning of Turubarov's case. So considering a fair trial implies these two elements, full and ex nunc. If a judge is not in the position to reconsider the whole case and take a decision which is completely new and incomplete with regard to the case, that's not what the directive establishes as a mandatory procedure for asylum seekers. Evidently, as a consequence, it is absolutely necessary to have a relationship between the appellate level and the determining authority, which is a hierarchical one, where the judge can tell to the administration what they could be doing. On the other hand, thinking about the compatibility between Hungarian law and the Charter of Fundamental Rights of the European Union, Article 47 of the Charter specifically says that the right to an effective remedy would be illusory if in member states legal system were not to allow a judge to have the final word on a case, but to actually leave it to a first-tier administrative authority. The very concept of fair trial as enshrined in the Charter of Fundamental Rights of the European Union is prima facie violated by the fact that an administrative office can simply ignore whatever the judge is saying. The end of the story is twofold. The first point is that the story of Mr. Turubarov teaches us that the most, sometimes, despite being unexpected, the most intense attacks to human rights and liberal democracy and rule of law specifically in member states that have opted for a specific political majority which has a so-called populist agenda do not occur on a substantive level, on a manifest, explicit level of legislation that very clearly declares to be willing to violate and trump human rights, but is actually carried out by amending procedural laws and changing small details about procedures that will have indirectly and on the long run the consequence of violating human rights and ultimately excuse me, and ultimately impact the quality of the rule of law in the domestic system. The second point is that of the role of the European Union as the guardian of the rule of law, of democracy, vis-à-vis democratic decay, and if you want to call it in another way, populist agenda at a domestic level. Is the European Union the guardian of democracy in Hungary? Well, technically, they're not. Orban is not wrong. Orban and not Kaczynski as well. So neither Poland nor Hungary are completely wrong in saying that no one ever thought, no member state signed the Treaty of the European Union thinking that the Union would have been the guardian of democracy at a national level. No one ever thought that, and that was never one of the tasks of the European Union. But as a matter of fact, this is what the European Union is now called to do as a job because of the developments at a national level. And here you see this very clearly. In this case, what you can see is that it is not the role of the European Union to impose their own one individual procedure for applying for international protection. It is not the role of the European Union to impose on the Hungarian parliament one specific solution. However, it is the role of the European Union to interpret the treaty and the Charter of Fundamental Rights in a way that will guarantee that any national parliament who should interpret the European Union directives or the European Union legislation in a way which is incompatible with the rule of law and other fundamental values protected by the Union will be stopped. And this goes beyond fancy Article 7. This goes beyond the fancy rule of law assessment report. This goes beyond the declaration by the president of the commission. This goes beyond the bilateral talks between the president of the commission and Hungary and Poland and so on and so forth. This is a very detailed and very careful guardianships that the European Union has conducted at a legal level from the standpoint of the judges of the Court of Justice of the European Union in limiting the ambitions of populist leaders to trump human rights at a national level through amendments to very specific procedural laws. I'm going to stop here because otherwise I could talk for hours, but this would not fit the time limit that I was assigned. I'm happy to answer questions if you guys have any.
Thank you very much, Sara. Very clear and very interesting indeed, by the way. So I will keep for a couple of minutes just to see if there is any question. We have Leonardo. Okay, I think that we can allow you to speak directly, Leonardo, because we know you. As far as other people would like to talk, I kindly ask you to turn on the video first, and then I will allow you to speak. So, this risposta dal vivo, no. How does it work? I don't hear you, Antonio.
Leonardo can now directly ask the question. So.
Okay, thank you very much. Leonardo? Probably we should allow them to speak, otherwise how?
Oh, no, he is allowed to speak.
He's allowed.
I don't know if any problem has arrived, but in principle he could speak, I hope.
Leonardo, we are waiting for you.
I don't think I can turn. Okay, so Leonardo apparently, so let me try again, just to.
Okay.
Now, sorry, I didn't. I thought to have turned on, and no, I didn't.
Great.
Yes. Can you hear me now?
Yeah. Go ahead.
Okay. So, well, thank you for your presentation, first of all. And I believe you mentioned very briefly in the introduction how the Constitutional Court of
We don't hear you any longer, Leonardo.
I think I was disconnected for a moment. I was saying, I believe you mentioned very briefly in the beginning how the Constitutional Court of Germany did not accept the dissolution of a far-right party, I believe the National Democratic Party. And it is something I had followed at the time, well, not really at the time because I was too young, but I have read something on it. And if I remember correctly, the reasoning of the court was that the National Democratic Party had been so infiltrated by the security forces that you couldn't really discern genuine racist statement from the one made by undercover police. And this, I wanted to ask you if this creates an interesting question, because is really the police and the administrative level of the security forces the real tool to police political organization? Do we really want to treat political organization the same way we treat criminal organization to be infiltrated and dismantled? Are policemen and security service really the best tool to defend democracy in this way? Can they make the correct judgments, or are they just incentivized to treat them like criminals which have to be arrested no matter what? Yeah, that is a consideration, and I want to hear your opinion on it.
So Sara, if you would like to answer directly, so and then we gather other questions.
Yes, I'd love to. Thank you, Leonardo. This is a very interesting aspect of the doctrine of militant democracy, right? So the decisions that you're mentioning does refer to the problem of the role of the police. That is this is slightly general as a tag, as the people that were, you're not wrong, of course, but the people that infiltrated the party at the time and that conducted the investigation on the agenda and on the actual activities of the political party in order to gather evidence on the fact that they would qualify for a ban. We're acting on the basis of the mandate of a very peculiar office, which only the German system has, which is this Constitutional Investigation Office. It's a very specific branch of the executive government. I am not implying in any way that it's not part of the administration and that it falls under the competence of the executive, but it is a very, very peculiar, it is a very peculiar institution, a very peculiar structure that in theory is legitimized by the fact that it is protecting and defending the democratic system of Germany. Now, you are absolutely right. At that point, because of what had happened during the 70s, there had been a lot of attacks on individuals, especially people that were involved in the political parties as administratives and not maybe as political leaders. And these people were being ostracized and were being attacked due to the fact that they were part of these political structures. And over time, these had been, let's put it like this, political investigators had been carried away. And when the case got to the court, you're perfectly correct in saying that the Constitutional Court of Germany said, this is just not solid, a case which is solid enough, because the evidence that you and the actions that are being pointed at to say this political party is conducting anti-democratic and anti-constitutional activities were actually actions carried out by the infiltrated personnel. So that was quite a shaky base for the case, right? Interestingly enough, more recently, the Constitutional Court has came back to tackle a similar case, and it rejected it, saying 2017, they rejected the claim to declare our right-wing political party as unconstitutional due to their performance in elections. In other words, they adopted the so-called rule of the electoral performance. So if the political party doesn't really perform in a way where the electoral support is such to really put them into position to, let's say, transform into reality their anti-constitutional agenda, the Constitutional Court will not move forward with declaring the political party unconstitutional. But you're completely correct. And some say that most likely the Constitutional Court of Germany will never, it's a terrible word because the word is changing under my eyes, but it's very much unlikely that if things stay the way they are, that the Constitutional Court will again declare a political party unconstitutional. One last comment on this, bear in mind that when they declared basically the political party that was supposed to pick up the inheritance of the of the Nazi party in Germany was declared unconstitutional. That happened right away. The Constitutional Court, it took them 10 minutes to write down the decision, right? That was taken immediately. So it's very clear these people are doing stuff that are incompatible with the constitutional order. But when it came to the Communist Party, it took them 5 years to build that case. And if you read the decisions, they're very much different. And again, this difference and the way that the controversy that this different approach had triggered just led the court, and what has happened in the 70s, as you were remembering, with this hyperactivism of the investigative bodies, just had as a result the fact of slowing down and basically transforming the idea of banishing a political party as a very, very unlikely possibility.
Thank you very much. I think that Francesco Petronio could just ask a question directly.
Yeah, hello, Professor. Thank you very much for the interesting seminar. I can't open my video because I don't have the authorization, so I just asked the question. And without the respect of the rule of law in administrative proceedings, isn't there a big problem also for the common market of the European Union? I think, for example, about the procurement contract. Were there cases about this problem?
Now, I'm sorry, I missed your name. What, Francesco? Yes, yes. Francesco, if you are an expert, or you're studying, or you will be working in the field of administrative law, brace yourself, because with the I don't know if you've heard that the new European prosecutor is being created. Now, the new European Prosecutor Office, which is being created in Brussels, is an office that will have exclusively competence over the management of the funding of the European Union, which of course has an self-evident impact on procurement, right? And procurement rules. So we're gonna receive a ton of money and we're gonna have to spend it effectively. Now, for those that are passionate, those are Italians, those that are passionate about procurement law in Italy, and those that are passionate about corruption, we can have a separate seminar devoted to that, and how the code of procurement in Italy has been basically the golden child of every political majority that has gained power in Italy in the past, I would say 20 years. Since at least the European Union has kicked in as the main legislator on the thresholds regarding standards in procurement. But yes, it's exactly the same problem. And I anticipate, Francesco, that we will read very interesting decisions by the Court of Justice of the European Union, or at least very interesting, let's say, I don't even know if they're going to call them assessment paper, but any legal assessment from the European prosecutors with regard to procurement, specifically linked to the Next Generation EU Fund and the Recovery Fund. So I agree with you. And I think that we're going to read a lot about what the rule of law is with regard to that. I agree with you.
Thank you very much for the answer.
Thank you. So there is any other question? So I will abuse of my role of mediator asking you a question. So I was very interested in the case of Alexei Turubarov that you painted very well. It just came to my mind that this story is a story that deals with different grounds, not just the legal one. So deals with, first of all, the recognition of political authority of Europe. Obviously, from a political point of view, it is at the same time a diplomatic issue, because it deals with the relationship with the former Soviet Union, so the former major partner of Hungary. It deals also with the system, the Hungarian system itself. So from dealing with the autonomy between the judicial power and the political system itself to a certain extent. So given that, I wonder, do you think that there is a specific role of the populist ideology in the development, in the management of this case? Because I was really interested in what you said, dealing with the use or misuse of procedures of law. But I wonder if this is a specific aspect of this kind of ideology, or is just a general aspect of non-fully democratic, just to be kind, political parties that try to, get power and to challenge and from within the democratic system. So, but thank you very much. It was very interesting presentation.
Thank you. You're too kind. But it's because we're good colleagues and friends. So, but I appreciate it anyway. I totally agree with you. The Turubarov case does raise I find it interesting because there are details that I didn't share. So, for example, when Slovakia refuses to recognize international protection to Turubarov, Slovakia does that, breaching European Union law, breaching directives on the recognition of international protection, and sends back Turubarov on the basis of national interest and bilateral relation, if we want to be kind, you know, to use a gentle definition, on the basis of bilateral relations with Russia itself, and economic interest that Slovakia has with Russia, especially energy, from a point of view of energy, but not only. Also in terms of investments, Slovakia is very much linked to financial interest with Russia. So he gets sent back in breach of European Union law. And in theory, at that point, Turubarov was finished. He was back in Russia, and he did not have the resources, and if he didn't manage to get out of detention in Russia, because he's got the money, because he's got the lawyers, because he managed to do that, which is not for everybody, he would have been stuck there, and we would have not been hearing from him anymore. So again, Slovakia acted on the basis of national interest. Hungary, and I skipped all that part because it was too long, but at a certain point in the ping pong between the judge and the administrative office, immigration office, seeks for some assistance from the Ministry of Interior. And they ask them to make an assessment about what is really like in Russia, and is this guy really under threat? Should he go back, and so on and so forth. And the answer is, no, he's fine. I mean, Russia is fine. They got judges in Russia. The guy is going to go in trial. They're going to judge him, and then he's going to go to jail eventually. But there are detention centers in Russia that are not that bad. And they're, because all this idea that there is an autonomy at a domestic level to identify thresholds, despite whatever the European Union has identified as a common tradition and as a common threshold when it comes to fair trial and rule of law. And this leads me to your question. Yes, this is, to me, if we carried out a very interesting research, which was to compare the amendments, the changes to the procedure for asylum seekers and related laws. So it wasn't only about the procedures to apply for, but it was, so for example, like in Italy, would you be able to sign up at the municipal registration? Okay, so we considered everything. And we compared Italy, we compared Hungary, the UK, and Sweden, considering that all these countries at a certain point had a political majority, or at least a majority where there was a strongly populist sovereignist majority that had made anti-immigrant policies their super strength in the agenda. And we could show that in all these countries, all these political majorities, even when they were mixed majorities with, you know, coalitions between populist and non-populist, first thing they did, all of them, was to change the procedural aspects on international protections and application for asylum seekers and immigration-related rules. So yes, it is true. It's not only the populists that do this. Every authoritarian system, of course, and this is, you see, the dark side of the law, right? So the law can be can be a flower, but I guess it can also be a sword. So it depends who holds it. So if it's an authoritarian leader, there's nothing worse than legalism, because they're just gonna put you in jail and forget about you on the basis of some this tiny legal detail. So yes, you're completely right. I think that it particularly defines 21st century populists, though, the fact that the attack started almost everywhere on immigration law and international protection law, which again, if you were really to look from a legislative politics standpoint, like what would be smart in political terms as a lawmaker, it doesn't make much sense, because it's just communication. It doesn't really impact everyday life. I know it's banal to say this, everybody knows this, but it's important to say it again. So it's not going to make people richer.
Yeah, and also I think that is a point that is, shared and, allow, political parties to gain a lot of political consensus and of electoral consensus. So probably also could be an interesting, point of view from which we can look at this rise of populist parties in Europe, but not just in Europe.
Yeah.
Thank you very much, Sara. There is any other question from the public, from the audience? Because actually we are in perfect time, more or less. So if there is no other question, I'm very happy to.
I've seen Andrea Ferro, but I don't want to. I don't want to caught up in my own ego. I don't want to see questions.
I'm not sure. Yeah, I see it. So I tried to make for the first time this procedure.
Okay, so thank you for your speech. My question is very quick. So I would like to ask you just one comment on one of the very recent facts. So basically, I read that the European Commission is taking Poland to the European Court of Justice over the 2019 reform of the Polish legal system that would undermine, let's say, the judicial independence. So in your opinion, is, let's say, a political agreement the only way to overcome this sort of crisis, or can the legal system lead to a solution on its own without the political interference, let's say?
That's a very good question. 10 days ago, we organized at Johns Hopkins a seminar with Wojciech Sadurski. Wojciech Sadurski is a Polish/Australian, which gives him the freedom to say what he says, constitutional expert. And he has spoken out loudly about the bad direction that the Polish government has taken, especially with regard to the amendment on the rules of the selection of the judges of the Constitutional Court, and also on the reform of the judiciary that basically brings the judiciary under the control of the executive. We could have the same discussion about Hungary, but where the situation is even more complicated. But what he was, and he has been attacked, he has been sued for defamation by the government. The guy, he's being basically attacked, and he's not being allowed to speak on campus in Poland, and he's being cut off of all academic activities. So they're even curtailing his academic freedom as a scholar. Is it only, and what he raised during that talk was the fact that it is evident from a legal standpoint, no one has a doubt that all these laws are manifestly unconstitutional if we were to consider what the common constitutional traditions of Europe are. It is evident. And it is evident that the attempt there is to adopt a version of the liberal democratic state, which is not the one that we have been sharing and working on after the end of the Second World War. So, is the law enough? Yes, but when you will get to the point where Poland does not care about what the Court of Justice of the European Union says, law is not going to be enough. So my personal opinion is that inside the limits of sanity, we should try to open a dialogue about the possible options in implementing a democratic model of constitutional state based on the rule of law. In the limits of sanity, which also means that political actors will have to convene and to find a solution that can represent a compromise, an agreement between these different options, right? At a certain point, we will have to open some room and they will have to close some. However, having said that, I'm going to be honest with you, the geopolitical developments of the last few days have traumatized me, and I don't see any possible, I don't see future good developments happening. I think the situation is getting more and more complicated. My concern with suing Poland and Hungary, and I'm closing with this, my concern with suing and continuing with the legal way, with the legal actions, is that sometimes this backfires. And it backfires because it's like in real life. If your neighbor has been throwing trash in your garden for the past 5 years and you try to talk to him, then you brought him a cake and you try to become his friend, and then you try to talk to the rest of the neighbors to try to change his mind, and then you try to whatever, you know, you gave up, and then you started suing him, and you sued him once, and you sued him twice, and you sued him 3 times, and it's just not going anywhere. And he's just gonna get more enraged, and the situation is just gonna become unbearable, and it's just not gonna go anywhere. So sometimes the legal action does counterfire. So yeah, hopefully it will not, but it does.
Not such a positive point of view.
I am so sorry. It's just
ending up.
I've been reading the news. I should have known. I'm sorry.
That's true. That's true. I'm just, you know, asking Andrea if he would like to reply, but I'm not able to move.
I have no idea how you're doing this. You're very good, if you ask me.
Yeah, with the webinar after the hacker attack. So I try to manage my, you know, new informatic expertise.
Yeah, I'm doing great.
Okay, so I don't think that there is any other issue, or if there is, I'm very happy to listen to them, but no. Okay. So Sara, thank you very much for your contribution today. It was very interesting also, you know, knowing by other discipline point of view on the same subject is very interesting indeed for professor and for students as well. So thank you for being with us, and hope to see you also in person sometime.
Hopefully.
And discuss about these interesting topics. So thank you very much.
We will. It was a pleasure, you guys. Thanks for the invitation.
Thank you to the audience too, to the silent audience.
Exactly.
We have recorded the meeting, so we will upload soon on the Moodle platform, I think, of Professor Antonio Nicolò. Thank you very much.
I also forgot to share my email, but if you need to contact me, it's name.lastname@UniPD. So you can reach me there if you want.
Great, and we will also upload the PowerPoint presentation, so you will be able, your students will be able to use it. I mean, and to look at it. Thank you very much again. Bye bye.
Bye bye.